Ollman versus Evans, 1984. Ollman, the plaintiff, was a Marxist professor at New York University, a professor in political science, and he is suing the defendants, Evans and Novak, who are columnists who wrote an article about his nomination for chairman of the Department of Government and Economics at the University of Maryland. As a columnist, they get to express their opinions, and that was one of the reasons that the ruling came about. The issue was, did the article written by Evans and Novak damage Ollman's chance to obtain the position at the University of Maryland, and did it damage his reputation as a scholar? Throughout this case, there was many things brought up along with the First Amendment rights that we've been studying. The First Amendment rights allow us to have our freedom of speech, and as writers in Evans and Novak's case, their right to express their opinions. They are well-known scholars and well-known writers as journalists and columnists for the New York Post. When Ollman got nominated for the position, they wrote a column about his nomination and their thoughts on him as a scholar, him in getting the positions, and as a columnist, they expressed their opinion. It got published in the May 1978 issue of the New York Post. Ollman said that this actually damaged his reputation because of their opinions was against him instead of for him. That cuts into our ability to express our freedom of speech, as it talks about in the First Amendment. Throughout this case, there was a Ollman's test that was created. The Ollman test has 4 different parts. The parts are: can the statement be proven true or false? What is the common or ordinary meaning of the words? What is the journalism context of the remarks? And what is the social context of the remarks? That is what the jury used to decide the decision. The decision was not for the plaintiff, Ollman, but it was for Evans, who was the defendant. And the court ruled in the case that in this case, if they were not allowed to express their opinion, that would break into the First Amendment laws, which is against our Constitution, I guess you could say, and against the Bill of Rights. They sued him for $6 million, but he did not get a penny of it. Ollman was told that just as he teaches in his classes at New York University, people do have the ability to have their own rights and their own speech. There was a statement made in the article by Evans, and it said, Ollman's writing candidly professed the desire to use the classroom as an instrument for preparing what he, Ollman, calls the revolution. The part of this article for Ollman talked about how our nation is set up in classes, and classes as in, middle class, upper class, and how there needs to come about of having no classes whatsoever. Everybody has their freedom rights. If you're upper class, you have the same rights as lower class does. Lower class has the same rights as upper class does. So when the jury sat down to think about this case, they're like, if you are preaching this, why are you suing a man for doing exactly what you have taught in your classroom? So the majority decision was no. The decision was made by Justice Kenneth Starr on the behalf of the defendant. A few questions I want to ask for you guys to think about is, Ollman's scholarly excellence has been harmed, but would he have said this if he had not been nominated for the chairman's position? So when his charge was saying, hey, I didn't get the position because you wrote this article. But would he have, if they had wrote this article just about him being a professor in the classroom and they didn't like his teaching style, would he have still charged them? Or is it just because of the position? So that comes in with, if you're still against having different classes, if you're just a professor instead of a chairman, or a chairman instead of a professor, if you're preaching against having social classes, why are you suing on the behalf of, I didn't like this because I was trying to get a new position? And the other one I wanted to think, if a columnist had wrote the article, what if a student in his class had wrote the article? Would there still been a decision on to charge the student with, harming his reputation, or would he just said, they're in a learning situation, therefore it's a good thing for them to express their opinion? So my big thing that I was really stirred about in this article in this case was the fact of he teaches he doesn't want classes, he doesn't want social classes. Yet when it comes to his charging or how he sued Evans and Novak, it seems like the social class was the issue. So let's look over that and see how the social classes plays into this case as well. This case also, there had been a few times before that there had been a case like this come up. It is a constitutionalist. It is based on the Supreme Court's Gertz versus Welch, and it says, under the First Amendment, there is no such thing as a false ideal. However, opinions may seem, we depend on it for corrections, but the conscience can be made by the judge or the juries, but competitions are the ideal. I looked into that because I was kind of unsure what they were trying to say, and in that specific case, it was talking about people have their right to make their own opinions, and the jury and judge are not ones to say you can or cannot have that opinion, because everybody's opinion is their own. So I can say I love Jesus, and if you don't love Jesus, that's your opinion. I can't tell you your opinion is wrong because I am not who you are. So hope you guys are having a great day.